our program, the Steel Seizure Case in Historic Perspective, Presidential Power in Wartime. The chair of our program committee, David Frederick, is right over here on my right, and he put the program together, and we're delighted to present it to you. We're going to have the program videotaped so that others besides you can enjoy it, and we look forward to it. Our moderator is Carl Stern, who, even in your day, if you're young, you probably saw on NBC TV. He covered many of the great courtroom cases of our time, but I don't think he covered this one, but he knows about it. So I'd like to introduce to you Carl Stern, and he will carry the program forward, and in the course of it, you'll of course learn about the case, and you'll be introduced to our distinguished panelists. Thanks very much.
Thanks, Steve. We've got to think back. April 8th, 1952. The United States is in the middle of the Korean War. Heartbreak Ridge, Bloody Ridge, the Punch Bowl, combat deaths, missing in action passing the 40,000 mark. And after months of failed negotiations, the nation's steelworkers are about to go on strike. Defense Secretary Robert Lovett reports a long strike will cripple the supply of weapons and ammunition. Within hours of the expected start of the strike, President Harry Truman issues Executive Order 10340, directing Commerce Secretary Charles Sawyer to take control of the mills, to keep them running. In this courthouse, the argument was fashioned that may have taunted first the district judge, David Pine, and later the Supreme Court, into ruling that the president exceeded his powers when he issued the executive order. Maeva Marcus literally wrote the book on this case in her 1977 dissertation, Truman and the Steel Seizure Case, The Limitations of Presidential Power. So I'm going to start by asking her what got Judge Pine upset and launched this most famous constitutional dispute.
It's very interesting because, of course, it was supposedly, the seizure was supposed to be a new context in which to settle a labor dispute. You can't hear me?
Pull it up a little bit.
Okay. Can you all hear me? Yes? Anyway, the seizure was a new context for the labor dispute, and the industry went to court. The government didn't really expect a constitutional case after the preliminary actions for a temporary restraining order. The industry filed for a permanent injunction against the steel seizure, but another motion for a preliminary injunction which would be acted on more quickly. And that's an equitable procedure, and on an equitable procedure, the judge needs only to balance the equities. He or she does not have to go into the merits of the case. That is, the constitutional question was not foremost at all. And had the government lawyers done the proper thing, this whole dispute might have been eliminated. But the lawyer who argued the case for the government, Holmes Baldridge, was the head of what was then known as the Claims Division in the Justice Department. He was not an accomplished constitutional theorist, and clearly from the argument that followed, he was out of his depth. And I have to read this to you because it is truly astonishing. Maybe it won't sound so astonishing in today's context, but in 1952 it was an amazing exchange between Judge Pine and the constitutional and the lawyer for the government. The judge asked why did Holmes Baldridge think that the President could assert the power to seize the steel mills? And Holmes Baldridge said there was a grave national emergency that requires the exercise of unusual powers in these particular circumstances. And he said he didn't think any president would exercise such unusual power unless there was a grave and extreme national emergency. Judge Pine challenged that conception of presidential power. He said the government of the United States derives its power from the Constitution, and that those powers were enumerated in and limited by that document. Baldridge agreed that that was true, but only with respect to legislative powers. Insofar as the executive is concerned, Baldridge averred, all executive power is vested in the President. So Judge Pine said, so when the sovereign people adopted the Constitution, it enumerated the powers set up in the Constitution, but limited the powers of the Congress and limited the powers of the judiciary, but it did not limit the power of the executive? Is that what you say? And Mr. Baldridge says, that's the way we read Article 2 of the Constitution. He had no conception when he said that of actually what he had said.
Let me ask Lou Fisher, who was an expert on presidential war power. Did Harry Truman, what Baldridge said, did this really reflect President Truman's view of his own powers?
Well, he spoke as though it did, because at news conferences, the reporters would ask if you can seize steel mills, if that's your emergency power. Can you seize newspapers? Can you seize radio stations? And Truman said, I can do whatever is necessary in an emergency. And that was his conception of presidential power. I don't know how much the public understood that what was happening in the courtroom, but the public understands what's happening in a news conference, and the newspapers were picking it up. So they already were going at President Truman to see the practical implications of his theory. I mean, can you seize anything around the country in a state of an emergency? And the answer was yes. And as Maven knows, in the courtroom, Baldridge told the court there are only two checks on the president. One is the ballot box, and one is impeachment, and that's it. And no judge in the country can control the president.
Quite apart from legal questions, as a political argument, this was at a time, I believe, and you'll tell me, that there was already a great deal of indignation at some assertions of power by President Truman. The Korean War, which was undertaken without any declaration from Congress, the integration of the armed forces, the firing of General MacArthur, any number of things that we could recite here. Was this not already a point at which there was a certain amount of anger at the President's assertions? Yes?
Well, it's a good question on when this case comes to the court, because I think if it had come, Truman intervened in Korea in June of 1950. Had that case come late in 1950, early 1951, before the public tired of the war and soured on it, he might have got a different result. But by the time it comes in 1952, it's a calamity for Truman, and it's fairly clear that the Democrats will lose the White House to Republicans.
Before we go too far, yes.
I just sort of disagree a little. All of you saw the poll about what low esteem Truman was held in 1952, and all of that is true, and everything that Lou said is true. But what's very interesting is that immediately after the seizure, before the court argument that I just read to you, they did public opinion polling, and a majority was in favor of what President Truman had done. There was great sympathy for the labor unions. You know, they get forgotten in this whole constitutional ruckus, but they had postponed their strike for a good long time.
Stan Temko was one of the lawyers for the steel industry. You got a gift, didn't you? Did the steel industry expect that kind of overreach by the administration and the argument it was making?
I think, to put the bottom thing down, it was probably the worst work by the government in a major case. I mean, they did absolutely nothing right, nothing at all. And they started off on the wrong foot and ended up on the wrong foot. Now, one of the things that you can figure, I think if they had done a little better job, even though Pine clearly would have been glad to knock this thing down, if the government had tried it in a more reasonable fashion, I don't think he would have been able to get to the point where he just said, well, I'm going to the thing and declare everything unconstitutional. We'll never know. But what I wanted to say on the thing, people talk about what effect oral argument can have on a case or briefing, and it's very few cases where it has a real effect. Here, the government started off doing something wrong and never did anything right. The first thing they did wrong, which was interesting, was they took out the brief in the Montgomery Ward case, which was a seizure during wartime. Some of you with white hair may remember the picture of Sewell Avery being carried out by U.S. Marshals from his office and so forth. But that was a brief on the merits, and what they did for this, instead of talking mainly about the equities and the preliminary things, they took that whole brief and copied it in the first brief they filed. So it was sitting there for someone like Pine or someone to go to the merits. They had 40 pages of briefing on the merits, which you would never have done if you were focusing on the initial thing. Then where they got the idea, except there was a period in flux, to have Holmes Baldridge argue is another thing. He just was out way beyond his depth.
I have to ask Professor Paglia, I need somebody to speak for the Truman administration, for the executive branch. Wasn't there a real emergency here, or was that just nonsense?
I think I've broken my microphone, but oh no, it works.
Did Truman get bad advice from the Secretary of Defense, Lovett?
I mean, I think you have to distinguish. There's legal advice that he got somewhere along the line, right, about his power, his inherent power or lack of power to seize the mills, and then there's the factual advice that he got about what the consequences of the steel seizure, of a steel stoppage would be, what those consequences would be. And, you know, if we look at it in hindsight, it's quite obvious that that didn't come to pass. So I think that advice of the consequences, there was much more inventory in the steel companies than I think people thought. And so I think that factual advice was bad. Now, the legal advice, the legal strategy, the tactics that were used may have been bad, but they weren't initiated by Holmes Baldridge or by that Justice Department or anything. And to me, you know, the Montgomery Ward brief story is interesting. It's because it's not as though this was something that wasn't done. It's not as though this legal advice hadn't preceded the Truman administration. Maybe, you know, it hadn't been applied to this specific factual circumstance, but this did not originate with the Truman administration.
Can we resolve my question? Was there a real emergency or not? Yeah.
Well, what Truman got the advice that there was an emergency, and that's all I think that he ever saw from his advisors. But what happened in the 2 months between the seizure and the Supreme Court decision was there was a rationing agency because of the Korean War. And Truman was given, quote, war powers by the Defense Production Act so that he could manage an economy to support this police action, as they called it. But in those 2 months, everybody knew steel was rationed, and Truman said we needed steel, and he didn't want any interruption in the steel supply. The problem was that the agency that dealt with steel released steel for non-war purposes. And this was reported in the newspapers. Steel was being released for bowling balls, for bicycles, for whatever. And the fact of the matter is that there was no emergency, and, the proof is in the pudding. There was a steel strike for 2 months, and it didn't hurt the troops in Korea. But he didn't know that.
Was this thing a hoax? Wasn't this really an attempt by industry to push the government into permitting an increase in the price of steel? Wasn't this a contrived dispute?
Actually, what the Bush government would do for these things, as far as seizures, will depend very much on the situation at the time. And the concept of saying when they can get away with something or not get away with something is going to depend very much on what's going on. In other words, if you look down this and there was some sort of an episode where they killed a couple of thousand Americans on Tuesday, the president would probably get away with a hell of a lot at that point. And probably the best thing you would hope for is not to have executive action stop, but hopefully that going with it would be some protection of civil rights and so forth.
Well, the industry was buying time. They wanted to make sure that if, in fact, the plants were taken over, that the secretary, that the government would not order some kind of wage increase, right? And so their quest, as the case moved forward up the chain, was to obtain, and they did in the Supreme Court, an order freezing wages at that current level, right? So
it was really, your question points to something. People shouldn't forget this wasn't any case involving saboteurs coming up on the Long Island coast. It was a labor dispute,
that morphed
a very limited labor dispute. Really, some people would say it was just a dispute about the price of steel.
John Barrett, you're the biographer of Justice Robert Jackson. Do you think Robert Jackson looked at this simply as a labor dispute?
No, I think he and each of the justices took it seriously as the presidential power question that they decided. But, of course, they decided it in the real context. I think Lou's right that 1952 and almost 2 calendar years into Korea is part of that context. I think Meva is right that Harry Truman, being a declared non-candidate and being at that time lowest recorded presidential popularity in history, is part of the context. I think, frankly, a majority of that court being Roosevelt administration New Dealers who had known a real president and looking at the president and the executive branch of 1952 is part of the context. I think the disaster that was the Department of Justice in 1952, the Attorney General, the Solicitor General, et cetera, was part of the context. But I don't think that they were making Defense Department or President-type threat determinations. They were taking Baldrige and government and Perlman at their word, the government at its word, that there were national security considerations, grave ones, in the mix. The question was simply a matter of presidential authority.
I love some of the headlines at the time. I noted that the New York Daily News, with respect to what Truman had done, wrote, "Hitler and Mussolini would have loved this." The Chicago Daily News called Truman's order leaping socialism, right? So did this have no influence on the court?
No, I think it had huge influence. Lovely papers survived from this time period because it was a pen, ink on paper generation. No email, no hard drives, no retrieval problems, and people were pretty scrupulous about saving their materials. So Justice Harold Burton, for instance, has 3 folders of correspondence that he received from citizenry about the Steel Seizure Case. And it's in the run between the Pine decision and the oral argument. And there's not one letter supporting the president. This is a Republican, a former senator from Ohio, a former mayor of Cleveland, and the mail is overwhelmingly saying what's at stake here is the American way of life, freedom, property, liberty, stop this tyrant.
Dr. Marcus, you started to allude to this before. There were other weapons that were available to the administration. The Defense Production Act, the Selective Service Act, provisions for seizing essential.
Yeah.
So why weren't those employed?
They weren't employed because the procedures that were involved would have taken too long. They would have had, you have to award just compensation. You had to do it in courts all over the country. It was very complicated, and that would have given the union time to strike, because the minute the union strikes, I mean, I knew nothing about the steel industry. I learned this when I wrote the book. The furnaces are banked, and even if the strike legally lasts 1 hour, you lose a week's production of steel. So what the administration wanted to do was to avoid any interruption. And I think most of the advisors, and they did go over all of this very thoroughly in the weeks leading up to the seizure, whether they could follow the letter of the law and seize the steel mills accordingly. They decided they could not, that the president's power would be the easiest way to do it.
And the proof may be in the pudding. Skipping ahead, we'll come back in a moment to the Supreme Court decision, but in skipping ahead, after the Supreme Court invalidated what the president had done, in fact, Taft-Hartley was invoked, and it didn't work.
No, it wasn't.
Right? Was it not?
No, it was a 2 month.
Well, there was a cooling off period.
The president did not invoke Taft-Hartley. He believed that he had basically fulfilled the intentions of Taft-Hartley by doing all of the negotiation that he did pre the steel seizure. The strike had been delayed far more than the 80-day cooling off period. Right? So he was never going to impose Taft-Hartley on the union. And he didn't. They just went out on strike.
Lou?
Yeah, I think that was part of his problem. John talked about the context here. Truman found himself isolated. Instead of working jointly with Congress, he did not use the cooling off period, and he, Mavis said, worked long enough so he could not ask another 80 days. So he had taken the statutory procedure and ignored it. But I think even more important, and Carl, you mentioned this early, did Truman come to Congress? This is the first time a president has ever gone to a major war on his own and never come to Congress for authority. And he didn't go to Congress. Instead, he goes to the UN Security Council for 2 resolutions. And when the Senate debated the UN Charter as to military actions under the UN, Truman was in Potsdam at the time, and he cabled the Senate while they're debating the UN Charter and said, I promise in this cable that if I ever use U.S. troops in the UN action, I will come to Congress, both houses, and get authority first. And he never did. So he found himself isolated out on the limb, and when he was going down, he told Congress, if you pass legislation restricting me, I'll comply with it. But at that point, Congress says, you're out by yourself, and let's see what happens.
When the case got to the Supreme Court, it was argued by John W. Davis. The Solicitor General represented the United States. Stan, I gather that was another occasion when the administration did not do well.
It was a funny thing.
You were there.
Perlman wasn't that bad, but he had a very bad time in the Supreme Court. And something that is fairly common, at least it was in my day when I was clerking, if you were really one of the leaders of the bar, usually they treated you with great deference and didn't ask you that many tough questions. And in fact, a judge will come in off the bench and say, gee, I didn't think he was as smart as he was supposed to be. But now they treated Davis as though he was an exalted gentleman. He was very clear mentally still, but he was very, very feeble physically. And one of the interesting stories, and it got complicated, you had for the steel companies, and this was still the days of the famous steel companies, U.S. Steel, Bethlehem, Jones, and Laughlin. They all had ornaments of the bar, Luther Day, ex-governor Miller in New York, And normally, they'd all like to say something, and did say something in the district court. But my late partner, Westwood, who was always a pretty big fixer on this, said, I think we ought to have one person argue. And luckily, with Mr. Davis, all these tycoons could say, well, if only Mr. Davis is going to talk, I won't ask to talk. But if other people are going to talk, I'm going to talk. So they then, this was all agreed upon, but they were worried that Davis would either collapse or not get up for the argument. So there was a secondary thing that in the case that Mr. Davis got completely incompetent or down, then Bruce Bromley of Cravath would be allowed to argue, and no one else would. And that also went back down. Now, they didn't really ask Mr. Davis hardly anything. And as has been pointed out, he pretty much read his argument and didn't really ask for rebuttal because Perlman had pretty much self-destructed.
This case was not considered on the merits by the Court of Appeals. Would it have, two of the justices subsequently said they would have preferred that it had been sent back for that purpose, I think Burton and Frankfurter. Would it have made any difference in your judgment?
If what?
If the case had been heard by the Court of Appeals prior to its disposition by the United States Supreme Court?
I really don't know. I'll tell you, the big thing to me, the question is not so much that. If this thing hadn't gone bad for the government right from the start, with a Pine who really answered to no one except himself, would have somehow gotten to the point that he was going to say that this whole thing was illegal. I think if the government had done a better job, he would have been very, very hard put to get to that point, and I think he'd have a harder time having it upheld in the upper courts. In other words, I personally think if the government hadn't screwed up so bad that the case would have never gone this way. This kind of case should have disappeared finally. In other words, they argue about the equities, pro and con, and nothing ever comes. It sits in front of the court and isn't decided. And it was only because of the way the government approached it that it was able to go, went through, just on sort of records, it went through 3 courts, starting in a district court and going through the Court of Appeals and then the Supreme Court, and as I recall, a little less than 2 months. That's absolutely unbelievable. But it all goes back, and it changed mainly because you've had some quotes here, but that was quite graphic when Pine had Baldrige on the thing, and Baldrige was saying that there was no check on the president, and Pine said, well, what if you arrest me and tell me you're going to hang me tomorrow? What can I do? And he said, either go to the ballot box or impeachment. And this literally ended the thing. There was laughter in the courtroom, all the journalists did there, and that really lost the case.
Well, maybe that's the unitary executive. We'll get into that in a few minutes. Let me go first to John. This case, Youngstown Sheet and Tube, stands principally for Justice Jackson's formulation, this sort of trichotomy, can I call it, where presidential power grows from the minimum to the maximum, depending upon whether or not you add congressional authorization to what the executive has done. How useful really is that theory? Won't the executive branch always assert some congressional underpinning and authorization for what it's doing?
Well, I think it's quite useful as a structure for the conversation, but there's a classification question that comes first. This tripartite scheme is applicable in a situation where the President is engaging in activity that the Court classifies as legislative in nature. And only then do you sort out how much the President is able to do given what Congress has given him or explicitly or impliedly has taken away or has left in the zone of twilight.
What's legislative about a taking?
It's a piece of legislative activity. The typical condemnation action is taken by legislative action, and so that's the Court's classification move. It's pretty subtle and rushed past in the Youngstown opinion, but I do think it sort of leaves to one side things that are in the executive sphere, things that are not legislative in nature, and so that's one thing that maybe makes it less universal than we quickly and casually think it is. Once you're into this realm, I think, it's sort of like Goldilocks. Jackson's three-part scheme is a nice shorthand that everybody comprehends, immediately. Too hot, too cold, just right. Permitted, prohibited, or got to figure this out. It's in the gray area.
Well, this is all nice,
but it doesn't then tell you how to answer the question in the gray area. It tells you how to answer the questions out on the two ends.
Okay, this is all very nice, but this is time of war, is it not? Lou, does that make a difference?
No. On the getting back to Jackson's three categories, he himself, before describing them, said this is simplified. Mm-hmm. So those who think that if it's in category 1 or 2 or 3, you've got the answer, that's nothing I think he ever anticipated. And in fact, if you look at the more recent situation with NSA surveillance, some people argued that presidential power was at its lowest ebb because President George Bush was going against the FISA statute. And then, of course, the Justice Department would say, no, it's not in the lowest category, it's in the highest category because he's acting with the authorization for use of military force. I think you can see that this can be gamed pretty easily by different sides and not give you an answer.
And in fact, John, when Justice Jackson was Franklin Roosevelt's Attorney General, right, in 1941, whatever it was, he wrote an opinion in the North American aviation plant strike case saying that to prevent a disruption in the manufacture of aircraft, that the President had inherent authority to maintain the U.S. defense effort. How come in 1952 he's saying something different than he said in 1941?
Well, that's a wonderful replay of what Philip Perlman largely did in his oral argument, looking right at Jackson and actually wagging his finger. I think tactically it was one of the unfortunate things that Perlman did in the case. But it did force Jackson to think hard, and I think he tried to think honestly about how these situations lined up against each other. Footnote 17 in his opinion is a series of factual distinctions that he draws between the case that he authorized as Attorney General for Roosevelt in 1941 and how he saw this case. I don't know that it's fully satisfying, and he adds a sort of charming disclaimer that when one is an advocate, one does certain things that later one in a different role might reconsider.
Professor Belia, you wrote on the 50th anniversary of this decision in an article that this case sends a mixed message. Okay, so tell me what's mixed about it.
Well, two things I'd say. The first thing is that I really think of Youngstown as being a case two different ways. One is that it has a very strong sort of rhetorical or symbolic quality to it. And I think Maeva Marcus does a beautiful job in her book of pointing out how the court or courts have used it over time, particularly in the 70s, and they throw Youngstown out there and it's kind of like saying, there's an abuse of government here and it just can't stand. So it has this rhetoric and sort of rhetorical symbolic quality where it's standing for the proposition that law isn't law just because the government says it is, right? So, and I think it sends that very strong message. Actually, my favorite recent use of it in that form is in the Clinton versus Jones case, where it's completely off the wall citation to Youngstown, just to sort of say, all the time we tell presidents that they're acting badly. But I think as a sort of a doctrinal tool, I would pick up on things that John Barrett and Lou Fisher both said. I think that there's a lot of manipulation that can go on within Justice Jackson's framework. You have this first category of that he describes as where Congress has expressly or impliedly authorized. And that impliedly all of a sudden sort of throws in a big hole. It means not necessarily by statute, but by some other indication. And the Court, has sort of run with that in cases and found implied authorization where I think, frankly, it's not there. So I think that what it does is, on the one hand, it's saying, be careful because there's this Youngstown case and surely the President can be stopped. But at the same time, there are so many sort of holes in the framework that it allows power to kind of just lurk out there.
During the Civil War, Abraham Lincoln seized all the rail and telegraph lines leading into Washington, D.C. No statute authorized him to do that, okay? Would Youngstown Sheet and Tube, how would, if that matter had been litigated, if we could turn everything around and there had been Youngstown Sheet and Tube, how would that have come out?
A real shooting war is an entirely different thing. Justice Clark, in his opinion, he's the sixth vote, concurring only in the result, has I guess it's a piece of dicta, a little formula saying, although this case is about Congress having not given the President he exercised, in a different case where it's silent, then we would look at the seriousness of the threat. And in a real dire situation, of course, a court's not going to get in the way. And I think, that's constitutional law boilerplate. We don't need the court to hold that. When the rebels are on the railroads converging on the nation's capital, the President gets to fight back.
Well, I'm not sure what kind of standard we have. In Youngstown, Justice Jackson wrote that when the President acts in the twilight zone of shared or uncertain powers.
Zone of the twilight. The twilight zone is a TV show. Zone of the twilight.
Right. He changed the phrase because it sounded too TV-ish.
He said the imperatives of events and contemporary imponderables determine the outcome. What kind of standard is that?
That's exactly it. That's contemporary imponderables. And Jackson's opinion concludes by pointing the finger back at Congress, saying the power resides there and it's theirs to be exercised or to be squandered. And he wasn't a big one on thinking these executive power questions were inherently justiciable, that the Court's role in national security matters was a big one. When the Court grants cert in this case, he passes. He doesn't vote to grant cert. When the Court votes to stay the case, he's the only one to vote against the stay. Truman's still negotiating. He wants the President to work this out with the industry, with the union, with the legislature.
I'm still trying to find out whether Youngstown Sheet and Tube still lives and whether it means anything.
Yeah, Lincoln did what Truman did not. Lincoln took certain emergency actions, what we call the Lockean prerogative. You can act in the absence of law, sometimes even against the law, for the public good. But then you come to the legislature for authorization retroactive, which is what Lincoln did, which is what Truman never did. Truman could have taken certain emergency actions in June 1950.
He did go to Congress the day after he seized the steel mills and said to Congress, in a message to Congress, if you don't like this, please tell me what to do.
But Lincoln's position was different, said, I don't think I have authority to do what I did, and the only way to make it legal is for you to bless it by legislation. And that was not Truman's position.
Wow.
Within the past week or two, the President has told Congress that its role with respect to Iraq and Afghanistan is to provide the money, and that when the White House invokes executive privilege, congressional contempt citations can't be pursued over the objection of the prosecutor's employer, the President of the United States. Does Youngstown Sheet and Tube give us any guidance with respect to these kinds of controversies, or doesn't it? That's the question. Ava?
It gives you some guidance, but not
Much.
an authoritative answer. For example, with regard to the Commander-in-Chief clause, is it Jackson? I don't remember who it was who said that the Constitution makes the President Commander-in-Chief. He is Commander-in-Chief of the Army and Navy, but it is Congress who has to give the President an Army and Navy to command. So there is a sharing of power in this respect. So it's true the final opinion was 6-3, but if you read the opinions very closely, the only two justices who say that there is an absolute separation between executive and legislative powers are Black and Douglas. You would get a vote of 7-2 in favor of presidential use of inherent power in certain circumstances, but you can be sure that all 7 would not agree on the proper circumstances in which that inherent power might be exercised.
Did President Truman overplay his hand in 52?
Well, Stan will support me on this. He really wanted to settle the labor dispute. I don't think he had visions of power. He did believe in presidential power, and he said the things that Lou said. But he was told by the Chief Justice of the United States that he would have a very easy time in the Supreme Court.
Yes.
Maybe he was encouraged.
Vincent, yes. Well, maybe he was just ahead of his time, Professor Belia. You think maybe if Truman had argued some kind of unitary executive theory, would he have done better?
Well, I mean, I think he did effectively, right? I don't see the big difference between a unitary executive theory and what was argued. I think I have to quibble a little bit with something that John Barrett said at the beginning, which is I really believe that the Supreme Court justices did not perceive the emergency here. I think that the way that I count this is exactly, I think, how Maeve Marcus does, which is that you have the two who say the president has no inherent powers whatsoever, and you have the 3 in dissent who clearly believe that he does. And then you have everybody else who acknowledges, in Jackson's opinion, is probably the most ambiguous, but you have everybody else who acknowledges that the president has some kind of inherent authority to act in emergency situations. And I just don't think that they perceive this particular case to be an emergency. So I don't think that, he was ahead of his time. I think it's a consistent argument that's been made over time, and this is one where the factual predicate didn't seem to be there in the justice's mind.
Well, I think we agreed before it wasn't an emergency, right? So that argument would not have worked.
Well, we've talked about Korea. We've left out the Cold War, and the other half of Truman's argument was that steel was a vital commodity for the construction of our nuclear arsenal to keep ahead of the Soviets in that moment. And, of course, we never had a nuclear war. So maybe it was exactly that vital in exactly those quantities to build exactly that arsenal. I don't know how you test that. I do think Tricia's right. What I meant about the degree of the threat was that the justices didn't write their skepticism. I do think that they were skeptical.
The decision rests to some extent on the fact that Congress had enacted the Taft-Hartley Act in 1947. John, if there had been no Taft-Hartley Act, okay, and therefore no negative authority, shall we say, cutting against the president's assertion, do you think the case would have come out differently?
Well, it's for some of the justices, yes. For Burton and Clark particularly, who I think are really the two pivot votes here. They're the Truman appointees. Clark, for goodness sake, had been Truman's attorney general. And after this decision, Harry Truman fumed in colorful terms about what a mistake it was to put that bozo on the court. Whereas Jackson, on decision day, sitting next to Clark, leaned over and said, "Tom, congratulations on deciding to be a judge." But I think that I do think that the statute and the congressional consideration and non-enactment of a seizure provision was at the core of how Burton and Clark saw the case. Without that, there were other seizure statutes. Clark thought the Selective Service Act was important. The government didn't, and other justices didn't. The wage stabilization statute was invoked by some. So it's a pastiche of statutes, but Taft-Hartley is the front burner issue. And that's where Congress decided the president didn't have this authority. And for the center of the court, as we're talking about it, that made this an easy case.
Dr. Marcus?
The Taft-Hartley Act did not have seizure authority in it, but I know Justice Scalia would have my head for this. But in the legislative history, one House did vote in favor of seizure authority in the 1947 Act. The other House, they had debates. And much of the debate was, we don't really need to give the president this power. He has it. That's what it says in the congressional record. So there's no seizure power in Taft-Hartley. In 1949, Congress attempted to repeal Taft-Hartley. In that discussion, one House voted to give the president seizure authority. The other House never voted at all. But those are the factual elements of this case. And I think some of the justices, mainly Felix Frankfurter, play fast and loose with that, without mentioning what happened. They try to use the legislative history, but not exactly factually. So I think it's just the way you look at it.
You mentioned something before. I think we skipped over a little too quickly. Did Fred Vinson, I'm sorry, not Fred.
Yeah.
Yes, Fred, Chief Justice Vinson actually tell the president it's in the bag?
Well, we don't have any document that says he told him, but everything that we know, Stanley will tell you too, is that he got that advice.
John, you've made a point to me at one point that if Franklin Roosevelt had still been president with his clout, that this case might have come out differently, that Truman was such a weakened president that affected the outcome. I believe you said this.
Yeah, no, I think that's part of it. And the war, the type of war and the type of commanding and chiefing that Roosevelt was doing, as opposed to what Truman was doing in this 20th month of the police action in Korea. I think that's a tall figure casting a shadow on something punier at the time Steel Seizure is going on.
The most recent invocation of Youngstown Sheet and Tube in a major Supreme Court decision was probably last year in the Hamden case written by Justice Stevens. Do you expect we're going to hear a lot more, Lou Fisher, about Youngstown Sheet and Tube in the context of these cases, or
Always. I mean, just look at the nomination hearings with John Roberts and Samuel Alito over and over and over again. So this is about as popular a doctrine that can be used both by nominees and by justices. But as we said before, it doesn't get you to an answer. It doesn't. It's your categories, and you can play it as you like.
Roosevelt, was the strongest and probably might have done something. But if you look at this thing, it's really quite unusual. You have the Chief Justice and the President playing cards about 4 nights a week. They're the closest friends. Truman wanted Vincent to run for president. He was for Vincent for everything on this thing. I guess the Truman daughter called him Uncle Fred and so forth. Mm-hmm. So if you have the Chief Justice tell you flatly, don't worry, you're going to win this case, just leave it alone, I guess you rely on the Chief Justice to deliver the goods. And I think he never thought that Clark and Burton would desert him.
John?
The propriety is impossible to defend. The prediction, I'm not sure, was such a bad one at the time Vincent allegedly made it. That's pre-April, that's pre-Baldridge, that's pre-Pine. And Justice Burton's wonderfully meticulous diary shows that even in mid-May, as oral argument is approaching, he thinks he's going to be a dissenter, that Truman's going to win this case. It took a while. I mean, there's David Pine on the wall, third, bottom row, 3 left from the exit sign. It took a while for his message to reach the public and for that to sort of circle back to the court. And I think that climate was completely different than when Vincent was telling Truman, you don't have a Supreme Court problem here.
In terms of the national interest, did this decision come out wrong? After the Supreme Court's decision, the steelworkers did go on strike, and there was a 53-day strike. And there was a statement subsequently by President Truman that, in fact, the strike had damaged the war effort. So maybe the court got it right as a matter of law, but maybe not so good as a matter of the national interest. Ms. Marcus?
In line with what Lou is saying, this has nothing to do with seizure power or presidential power, but I think the most important thing about the Steel Seizure case is the principle that wasn't enunciated until all the cases, all the tapes cases that came up during the Watergate era. You will remember that this case is called Youngstown Sheet Tube v. Sawyer. But you never heard Secretary Sawyer's name mentioned in briefs, in arguments, in opinions. Everything was presidential power. Can the president do this? Can the president not do this? In the beginning stages of this litigation, the government believed that a court could not issue an injunction enjoining the president, even though it was Sawyer who was theoretically seizing the steel mills. And the courts paid no attention to that in the end. And that was very useful to the courts when President Nixon seized the tapes. And he did it deliberately because there had never been a court case versus some president. There was Mississippi v. Johnson, but it was no good. So Watergate set the precedent, and that has stood the test of time, I think. And it was the Steel Seizure that led to that.
Over and over again, I'm struck by the fact that this is a case that really didn't have to happen. It's very serendipitous when you think about it. First, not only had that argument not been made in Judge Pine's court, they simply decided on what was a preliminary injunction on the equities, and they could have handled it in that manner. It didn't have to go in this direction. And yes.
Well, I was just going to go back to something you said before. Would the Court of Appeals ruled in a different way? I think you are absolutely right in the sense that when the stay came to the Court of Appeals, the vote was 5-4. And there was 5-4 in favor of the stay. The steel industry didn't want the stay at that point because they had won the case. But 5 of the judges thought that there was something to the government's argument and that it should be looked into in a trial on the merits. And therefore, I think had the Court of Appeals considered it, it might have gone.
Well, then shortly thereafter, yes, Professor
No, I just
Leah?
also was, I'm sorry. I just also was going to throw out there the fact that the case could have completely gone away at that point as well, because it was the stay that, and the prospect that Sawyer would raise wages that was kind of keeping negotiations going. It's once the Supreme Court comes in and says that Sawyer can't change the terms and conditions of employment, everybody walks out the door. So I think if it goes to the Court of Appeals and they've got the stay, then, then the case may even dissolve.
Well, that's so the second accident here. There came a time shortly thereafter where the parties were assembled at the White House. Is that right?
It was the next morning. The stay was issued on a Friday afternoon or Friday morning, and the parties were told to get to the Supreme Court, and Stan can tell you because he ran to the Supreme Court after he wrote the cert petition. But the Court of Appeals said, we will only keep the stay until the Supreme Court issues its order. Saturday morning, the very next morning, Truman convenes the industry and the labor unions. They come to an agreement. They had an absolute agreement. They went back to their respective industry union people to get confirmation that this was fine.
At this point, it's about over.
At this point, it would have been over. The case would have been moot.
But what happened next?
The Supreme Court granted cert on Saturday afternoon, and the news came out over the radio. And some people were listening to the radio and said, oh, my goodness. The Supreme Court not only granted cert, but it said that it issued a stay and said the government could not change the terms and conditions of employment. That is all the industry wanted.
No wage increase. No wage increase.
No wage increase throughout this whole litigation. You know, you talk about seizure, and the steel industry hired a public relations firm to get all of its views before the public. It was happy with the seizure as long as the government didn't raise wages. All the government did in the seizure was raise an American flag over steel mills. They kept separate books. They didn't take any property. They didn't do anything. But if they raised wages, then there would have been an injury. But as long as this thing continued the way it was going, the steel industry was perfectly happy. And we know that that's the case because I have to stand up for the government lawyers coming from a family of government lawyers. They did make a terrible argument, but the steel industry lawyers were not so terrific, Stan, in the district court. If they were really, Bruce Bromley was the only one who saw what was happening. The other lawyers were just like the government. They thought this was a motion for preliminary injunction, and even though they had addressed the constitutional question in the brief because the government had addressed it, they did not talk about it in the argument. Only Judge Pine talked about it. And finally, Judge Pine said to one of the industry lawyers, if I think this seizure is illegal, don't you want me to call it illegal? And this lawyer sort of hemmed and hawed, and Bruce Bromley got up and said, oh, yes, yes, we want the whole hog. And another lawyer said, oh, I wouldn't look a gift horse in the face. But they were not expecting this. They were doing the same thing that the government lawyers were doing.
So we have this wonderful decision. We're all very sentimental about it, right? It's become a, sort of a chestnut that is pulled out off the shelf from time to time. But I think as a bottom line, I have to ask you, and then perhaps we'll go to some questions from the audience, so we have about 20 minutes left. What is the vitality of Youngstown Sheet and Tube today? I'll start with Lou.
I think law professors love it. I don't think it has any great use, and I've never seen a Supreme Court decision or even lower court that's decided on the basis of the three categories that people always refer to. So I think it's fun for some people to talk about, but I don't think it's useful.
Mm-hmm. Okay. Dr. Marcus?
Well, I think it is useful. I don't think it is a precedent that's worth too much because of the number of opinions. But when I was writing the book, I asked the Office of Legal Counsel in the Justice Department, well, what do they think of Youngstown? I mean, after all, it does say the president can't do this. It says a lot of other things. And I was told by the Assistant Attorney General, well, we know Youngstown is there, but we also know that it gives us the opportunity to try our hand at whatever we want. So there is an open door. And as I told you before, my feeling is that it's important for the proposition that you can enjoin the president in certain circumstances. That has become the law. Nothing else has.
Mr. Temko, you wrote, had a hand in writing the cert application to the Supreme Court, so you have a particularly sentimental attachment to what the court did. What's your view? Is it still good law? Does it mean anything?
Yeah, I think it's a useful precedent, but it'll depend very much on how it's applied. Now, when you're talking about it now, and one thing you have to focus on is President George W. Bush. If you want to hang in there, they can't do a hell of a lot to you. In other words, whether you're worried about presidential power or something, he can string this thing out at least through the end of his administration and probably into the next. I think how this plays will depend very, very much on the situation, because I would think, and I'm repeating myself here, but if you had a real emergency, or what they would view as an emergency in the United States, some sort of episode where you kill a few thousand people, you're going to have a hell of a time getting people to say that the president can't do pretty much what he wants to do. That's my own judgment.
Professor Boulier, does it mean anything or not?
Well, I mean, maybe I'm repeating what's been said, but I sort of think of it as it's important for what it symbolizes much more than for what it actually says. So it's important that it happened. It's important that it was decided, but I don't think that you can just sort of graft it onto a lot of the controversies that we have now and a lot of the controversies over separation of powers that we've had in the past.
Because?
Well, you know, because there's nothing there, essentially, there's this majority opinion that all these people sign on to, but then they all disagree with it, essentially. We've got a majority opinion for 5 people, and then we have, you know, Douglas is really the only one that sort of sticks to it. We have Frankfurter writing separately, we have Jackson writing separately, sort of detracting from the main opinion in the case. And as for the concurring opinions, my feeling about them is that the way that they've been applied, and I worked in the Office of Legal Counsel in the Clinton administration, so I know that Youngstown is always hanging back there, but it doesn't really provide you that much useful guidance as an executive branch lawyer.
And is the weakness, let me ask John this, is the weakness of it that you can cite almost anything Congress has done as the kind of authority that Jackson was talking about? For example, the president, with respect to the Iraq war, certainly can point to the fact that after 9/11, Congress authorized him to take whatever steps were necessary to put down the terrorism, et cetera, et cetera. Is it because you can always find something that fits within the Jackson formula?
Well, that may be part of the problem, but we shouldn't kid ourselves that law from the past ever dramatically certainly binds us. You know, we will decide that for ourselves today with our own contemporary imponderables. What Youngstown does, I think, as a general matter, is teach and remind in different spheres that the answer sometimes is no, that the power is not limitless. Hopefully it teaches and reminds in the executive branch. I don't know that the president reflects on this, but his lawyers should be. And as it fits in context that they're considering, I hope they think of the Steel Seizure context. The Jackson enjoinder to Congress is, I think, the heart of the opinion, not the 3 categories. And I hope that on Capitol Hill the legislature thinks very seriously about what passivity versus activity means and how these questions get framed up. And I think in the judiciary, as a very general matter, the factual context will be different. Youngstown is, or I hope will be, a powerful parable about judicial courage and judicial independence. Harry Truman, and I think Fred Vinson's prediction to Harry Truman, was based on a sense of owning the court. And no other branch of government owns the court. The court's power, of course, is only in its persuasive communicative ability to earn our obedience. But I hope judges look at Youngstown as a reminder of their independence and something that encourages them to decide independently.
It may not be dispositive, but we're all glad it's there. That's what you're saying to me. Right?
Indeed.
Okay. We do not have microphones in the audience, so if you have questions, what you're going to have to do is really speak up, and I'll attempt to repeat the question into the microphone for you. Do you have any questions for members of our panel? Don't be shy. Way in the back. You're really going to have to shout.
Even in the backdrop of 9/11, you had the Supreme Court pushing back with the Iraq school case, the Hamdi case, and the Hamilton case. I guess my question that I'm really curious about, I know it's just speculation, is if you had the Steel Seizure court today, how do you think it would have come out in those cases? And do you think it would have come up with the same formula?
I'm not sure that I can repeat all that. You're asking if what came up today, would we likely have the same result?
If the terrorism case that had come up to the Supreme Court in the wake of 9/11, where the court really did push back in the executive, if the Steel Seizure court had been sitting instead of the court had, how the panel
If the Steel Seizure Court were considering contemporary terrorism cases, yes, I understand. Lou?
Let me take a crack, because we didn't mention one thing which I think is very interesting. There was a law clerk at the time, later became Chief Justice William Rehnquist, and he thought that Truman would win based on case law, and he was surprised that Truman lost. And Rehnquist, in his book on the Supreme Court, said that the tide of public opinion ran against President, both for Judge Pine and the Supreme Court. That's a very interesting admission, because the court is loath to say that public opinion ever affects the independence of the court, but it does. And I think with the Hamdi case and the Rasul Guantanamo case and Hamdan, I think you have a case where, had those cases come immediately after 9/11, you would have had a result better for the president. But after several years, it starts to turn against. And I think that's something we should remember. It's a democratic society. It's not done by case law all the time, and judges are conscious of what's happening in the outside.
Anyone else want to jump on that? John?
Well, the question really asks, would you trade today's court for that court? And at the personal level, you bet, because I have so many questions for those justices of the 40s and 50s. At the citizen level, I wouldn't. I think actually a later court is always in a better position, because it has the example and the decisional body of work and the historical learning of everything that went before. So, I don't view it as a 9 players versus 9 players, which team can put up more points. I think today's court has the smarts to use, if they have the will to use it, of what that court left.
Is there another question? Yes, sir.
1952 was a presidential election year. Of course, today, a case like this would prompt questions to the candidates as to what their position is. Back then, and I'm actually old enough to remember the 52 convention, back then the parties, of course, selected their candidates during the summer. In April, there were no candidates, so there was no one to ask. But during the later campaign, was the seizure case discussed and debated at all? Did it play any role? Did the candidates take positions on it? Was it just then forgotten about, or was it an issue at all during the campaign?
I think you all heard that. Was this matter an element within the presidential campaign of that year? Anyone know?
Just a quick one. I think about the campaign, I think Eisenhower felt that Truman made a political and legal mistake going to war in Korea on his own. And if you're familiar with Eisenhower, he did make a concerted effort to work jointly with Congress through area resolutions and so forth, and not go unilaterally the way Truman did. So I think that was one result.
Another question. I saw another hand here. Yes, sir.
One of the themes that sort of ran across the panel was the nebulousness that the Jackson standard has. They basically say any type of congressional statute gives the president at the zenith of his power. So my question is, when you have things like the executive signing statements, the president says, well, Congress passed this law, but I think torture X, Y, and Z, not A, B, and C. Do you think that could be effective in future court cases of using and exploiting this type of tripartite framework that Jackson set up?
Did you all hear the question? It was about executive signing statements and whether the president's attempt to limit what Congress has done through these statements, whether that in essence runs afoul of the principles we've been talking about from the Youngstown case. Yeah. Professor Belia?
Well, I guess, one of the things that's interesting to me is sort of the development, the movement in the court in terms of what sources are considered authoritative in terms of what congressional authorization is or what congressional disapproval is. And I think, with Scalia and others, we've moved much more in a direction where if we're looking for what Congress expressly said, we look at the statute and we look at the text and we look nowhere else. Now, interestingly, the way that Justice Jackson sets up his framework, he puts express and implied in both the top and bottom categories. In other words, you can have express and implied congressional authorization. You can have express or implied congressional disapproval. And I think what was really found in Youngstown was an implied disapproval. So I think maybe the signing statement wouldn't fly now, right, because it's not something Congress is saying, it's something the executive is saying. But I think a lot of the things that were found to be disapproval in Youngstown itself might not fly for Justice Scalia. Some of this, and it's funny because Justice Frankfurter, who uses this in his opinion, he actually says this from the bench when he's questioning one of the attorneys, and And I think it's Perlman who says, you know, it was stated that we didn't need this power in the push to revise Taft-Hartley. And Frankfurter says, well, we don't really care what people say, you know, in the Senate, or we care what they propose and we care what they pass. And then he goes in his opinion and basically finds this kind of category of implied disapproval. So I think, in theory at least, it could shrink, if you took that seriously as a way of interpreting statutes, it could shrink both the top and bottom categories, and then you're sort of in that nebulous middle ground.
Another question? Yes, way in the, we're going to have to be able to hear you.
I was just a little curious about the background and the outlook of Judge Pine.
The outlook of, and perspective and I suppose character and nature of Judge Pine. Yeah.
Judge Pine was a government lawyer. He was in the U.S. Attorney's Office. I think he had worked in the Justice Department at some point. Mm-hmm. And he was of what we would call a conservative disposition, but known as a very good judge. And Judge Bastian refused to sit on the case in the beginning because he owned some shares of some steel company, and he refused to sit on the case. Judge Pine said that his wife owned a certain number of shares in the steel companies. The lawyers didn't care. The lawyers would have settled for Judge Bastian. They thought it was perfectly fine for Judge Pine to go forward.
And the rest is history.
And the rest is history.
Another question. Do I see another question? Going once, going twice. Well, thank you. We're just thrilled that so many of you came today in the middle of the summer. We didn't expect that. And we're doubly thrilled that our panelists were willing to come in and be with us today. So let's thank them. We'll have a very brief coda from Steve Pollack.
Well, I wanted to say that I thought this was really a remarkable panel with fresh views, both of the case in its era and of the way the opinions and actions in 1952 look today. I learned something. I thought each of the panelists, with Carl's wonderful questioning and probing, brought an independence of mind to the issues, and it's a great credit to you, and I thank each of you for joining us, and we'll be interested to see you on the tape which we have from Hank Montez and his people. I also wanted again to thank both David Frederick and Miguel Estrada of our board, who helped put the panel together, and to remind all of you that the Historical Society is a membership organization, and while we don't have a large budget, we do solicit members, and you have a membership card in your program, and we hope you'll want to join in our committees and what we do. We bring the history of the administration of justice in this great federal circuit to life today. If you don't learn from yesterday, you're going to make mistakes tomorrow. So thanks for coming. We have a reception outside, and we invite all of you to partake of it and stay with us for a little discussion of our panel. Thanks again for coming. Bye.